The court hands down judgment today in the case of Whittington Hospital Trust and XX. An explanation of the judgment has been prepared by Lady Hale. I shall read it out on her behalf, as she is unable to present it herself. I should begin by explaining that the court has ordered that no one must publish or reveal the name or address of a claimant in these proceedings, or publish or reveal any information which would be likely to lead to her identification or that of any member of her family in connection with these proceedings. The issue in this case is whether the damages payable for a hospital's negligence can include the cost of having a child by a surrogate mother. The claimant, a young woman of 29, lost her ability to bear a child because of the admitted negligence of the defendant hospital. They failed to report accurately on 3 cervical smear tests and 2 cervical biopsies, as a result of which her cervical cancer, when detected, was too advanced to treat in ways which might have preserved her ability to bear a child. Before she underwent the treatment which made that impossible, her eggs were harvested, and she now has 8 in storage. She has always wanted a large family. She and her partner would like to try for 4 children using a surrogate mother. They could probably have 2 using her own eggs and his sperm, and would like another 2 using donor eggs and his sperm. She would prefer a commercial surrogacy arrangement in California, where there is a well-established system and the commissioning parents are recognized as the child's legal parents from birth. But if this is not funded, she will use non-commercial arrangements in the UK. Basing its decision on the 2000 Court of Appeal case of Briody and St Helens and Knowsley Area Health Authority, where the leading judgment was given by Lady Justice Hale, the High Court held that the claimant could have the cost of 2 non-commercial UK arrangements using her own eggs, but not the cost of arrangements using donor eggs, because that would not be replacing what she had lost. Nor could she have the cost of Californian commercial surrogacy, because that was contrary to public policy. Both parties appealed. The Court of Appeal held that the claimant could have the costs of both the own egg and donor egg surrogacies, and on a commercial basis. The hospital now appeals to this court. There are 3 issues. First, can damages to fund surrogacy arrangements using the claimant's own eggs be recovered? Second, if so, can damages to fund surrogacy arrangements using donor eggs be recovered? Third, in either event, can damages to fund the cost of foreign commercial arrangements be recovered? By a majority of 3 to 2, this court holds that the answer to all 3 questions is yes. Lady Hale gives the majority judgment, with which Lord Kerr and Lord Wilson agree. The law relating to surrogacy in the UK is complicated. In essence, the surrogate mother is always the legal mother unless and until a court makes an order transferring parenthood to the commissioning parents. The surrogacy arrangement is completely unenforceable. Either side may renege on it. It is not unlawful for the commissioning parents to make payments to the surrogate mother, but it is unlawful for surrogacy agencies to operate on a commercial basis in this country. There is nothing in UK law to stop surrogacy agencies operating on a commercial basis abroad, or UK commissioning parents from using their services abroad. Nothing which the claimant proposed to do would involve a criminal offence, either here or abroad. Damages for negligence are designed to put the claimant, as far as possible, in the position she would have been in had she not been injured, unless this would be contrary to legal policy or public policy or unreasonable. On the first issue, surrogacy would enable the claimant to have her own children with her partner, and there is a reasonable prospect of success. It is difficult to see, therefore, why the claim should not succeed. On the second issue, Lady Hale now thinks that the view she expressed in Briody was probably wrong then and is certainly wrong now. There have been dramatic developments in how the law defines a family, including the recognition that people may automatically become the legal parents of children with whom they have no genetic connection. Surrogacy arrangements using donor eggs and her partner's sperm are the closest one can get to putting the claimant in the position in which she would have been had she not been injured. So the second claim should succeed. On the third issue, the use of commercial surrogacy arrangements abroad, there have been dramatic changes in the law and social attitudes since the Briody decision. The courts have invariably made parental orders in favour of commissioning parents, even though they have used foreign commercial arrangements. Government policy now supports surrogacy in appropriate cases. Assisted reproduction has become widespread and socially acceptable. The law commissions have proposed a new surrogacy pathway, which, if accepted, would enable commissioning parents to be recognised as parents from the birth. Most of the items in the bill for a Californian surrogacy would also be claimable here, although they might not cost as much. It is not against the law for a commissioning parent to pay for a commercial surrogacy abroad. Awards of damages for foreign commercial surrogacy can no longer be regarded as contrary to public policy. However, there are important factors limiting awards for surrogacy arrangements. Both the treatment programme and the costs must be reasonable. And it must be reasonable for the claimant to seek foreign commercial arrangements rather than make arrangements within the UK. This is unlikely to be reasonable unless the foreign country has a well-established system in which the interests of a surrogate mother, the commissioning parents, and also the child are properly safeguarded. There can be no question of children being bought and sold. Lord Carnwath, with whom Lord Reid agrees, dissents only on the issue of foreign commercial surrogacy. There is a principle of legal coherence which aims to preserve consistency between civil and criminal law. It would go against that principle for the civil courts to award damages designed to pay for conduct which, if it took place in the UK, would offend against the criminal law. Society's approach to surrogacy has developed, but there has been no change to the laws prohibiting the making of commercial surrogacy arrangements, which led to the decision in Briody. However, the result of the majority judgment is that this appeal is dismissed. Lady Hale very much regrets that she is unable to be here to present this summary in person, as this is the last case which she heard as President of the Supreme Court. But she congratulates the Court on continuing to make these broadcasts possible in such difficult